What if your land is treated as someone else's asset in insolvency? Imagine this. Your company buys land, remains the recorded owner and only gives development rights to a builder. But later, during the corporate insolvency resolution process of that builder company, the same land is shown as a corporate debtor's asset based on a disputed board resolution and sale deed. This is the story of GBP Developers Pvt Ltd versus Resolution Professional of Gupta Builders and Promoters Pvt Ltd, decided by the National Company Law Tribunal Chandigarh Bench on the 10th of December 2025. GBP Developers purchased the land in 2017, remained owner in revenue records, and entered into a joint development agreement with Gupta Builders, which is the corporate debtor. But during the corporate insolvency resolution process, the resolution professional treated the land as belonging to the corporate debtor. GBP Developers approached the tribunal saying it never transferred ownership. The board resolution was invalid, no proper meeting, no authority, and the sale deed was forged with no real consideration, and that it had already filed a civil suit challenging these documents. The resolution professional opposed the application, stating that this is a civil dispute involving title forgery and validity of documents, which requires detailed evidence and cannot be decided in insolvency proceedings. The NCLT held that under Section 60, subsection 5, it cannot act as a civil court to decide complex title and forgery disputes, and such issues must be adjudicated by a competent civil court. The tribunal further held that once the asset is part of CIR and the resolution plan is approved, such late challenges cannot be allowed to derail the process. The National Company Law Tribunal dismissed the application as not maintainable and refused to interfere with the corporate insolvency resolution process. Do you think insolvency forums should decide ownership disputes or leave it to civil courts? Follow Nova Legal for sharp judgment breakdowns.